Welcome to the NNBN podcast, talking with businesses, charities and organisations across Northamptonshire.
Sponsored by Poppy Design Studio. Find us at poppydesignstudio.com.
The NNBN Awards are now open for entry until 30th of June, recognising achievements of Northamptonshire's businesses, charities, individuals and organisations. Visit nnbnawards.co.uk to enter today.
So welcome to another podcast, and it's great to be here. It's Simon here. You haven't got Marie. She leaves all this to me, but we know at the end of the day she's the brains behind the whole business, don't we? But there we go. This is my chance to express myself, get a chance to talk to people locally about what's going on, help them get their message out there, and I thoroughly enjoy it as well. So if you would like to be here on the podcast channel, please do get in contact with us. hello@nnbn.co.uk, or maybe pick up the phone and call us 01536 6483 83, and we'll get you on the podcast and talk to you about what you get up to. So my guest today is Jennie Jahina from Wilson Browne Solicitors, who's a partner and head of the employment team at Wilson Browne. So Jennie, welcome today.
Hi Simon, thanks very much for having me.
No problem at all. Thanks for joining us. We've got a couple of topics we're going to be talking through, which I think are quite sort of topical and quite relevant compared to where we are at the moment, which is around the changes in employment law, AI in the workplace, and a really important one about getting people back into the workplace following the COVID restrictions and the way that life's changed a bit. But before we sort of talk through those sort of subjects and everything, Jennie, do you want to give us a bit of a background to yourself and tell us all about yourself?
Happily, Simon, thank you. So I head up the employment team at Wilson Browne Solicitors. We tend to act for a variety of businesses ranging in size from your owner-managed businesses through to the multinational businesses and pretty much everything in between. We try to pride ourselves on offering a friendly service, down to earth, and try to give the advice in a pragmatic and fairly easy to understand manner. I don't know whether that was a load of rubbish, Simon. Sorry.
It's you. Do you want to re-record it?
Okay. Yeah. We are So I head up the employment law team at Wilson Browne Solicitors. My colleagues and I provide advice to clients that are both in the business sector as well as some individuals. We tend to act for businesses which range from the owner-managed businesses through to the multinational businesses. So provide a variety of advice on every topic you can imagine as far as employment law is concerned, through to how do I take on my first employees, through to the performance management and general life cycle issues that sometimes arise, through to departing with the individuals. In particular, at that end of the game, we look at how businesses might be able to best protect themselves and protect their interests from someone who may be departing from a fairly key role. We also deal with the data protection issues that beset businesses, as well as modern slavery. And when we have at the time, we also provide some form of corporate support to our corporate team, where they deal with companies that are buying and being bought or sold.
Brilliant. There's quite a lot going on there at Wilson Browne within the role then. And as I said in the introduction, we're going to be talking through 3 topics today. The first topic, though, is around the forthcoming changes of the employment law. So, Jenny, I suppose a good place to start is, when do these actual changes take place, and what do they sort of look like?
Well, 2024 looks like it's going to be a fairly busy year with legislative changes, quite apart from any case law changes that come about. We've already had some changes that have come into force. That happened earlier this year in January. New guidance was issued for those calculating holiday pay for irregular workers, or those workers working irregular hours. That legislation actually comes into force on the 1st of April. The other legislation that also comes into force that day will be in relation to the national minimum wage. And there's been quite a few column inches there, headline being that for the over 23s, the hourly rate will go up from £10.42 to £11.44. So that's quite a significant jump. We will also see a little later on in April a change to the Employment Relations Flexible Working Act. That's going to bring in some changes where individuals will be able to make a flexible work request from day one of their employment. Previously, they had to wait 6 months into their employment before they could make the request. They can also make up to 2 requests a year, whereas previously they could only make 1. And rather key is that employers will now have a reduced time frame for dealing with those requests. So whereas at the moment they have 3 months to deal with them, that will reduce down to 2 months. We've also got the Carers Leave Act coming into play on the 6th of April, and that's going to entitle employees, again from day one of their employment, for up to 1 week of unpaid carers leave in any 12-month period. So that's going to apply to any employees who have a dependent with a long-term care need, or those employees who want to be absent from work to provide or arrange care. We've also got some changes to the maternity leave, adoption leave and shared parental leave regulations. They will extend certain protections as far as some pregnant women are concerned. That will predominantly relate to when they're returning from a period of maternity leave or adoption leave, and also returning from shared parental leave. We've also got then later on in the year the Worker Protection Act. That's looking at coming into play in about October, and that piece of legislation will place all employers under a statutory duty to take reasonable steps to prevent sexual harassment in the workplace. So I think that's going to be quite a significant sea change, that again will see employers needing to ensure their policies are really up to date as far as that's concerned. In May, we will have some new legislation with regards to the allocation of tips, which will hit the hospitality sector.
So there's a lot there going on this year, Jenny, a lot of change, a lot of information is going to need to be flying around. But of course, there's yourselves there that can help support local employers that are looking for further information. I suppose a good question to start with is a flexible work request. Do you want to sort of go into that in a little bit more detail, what that is? And because I'll be honest, we run a small business. I don't have employees, but there are smaller businesses that maybe are looking to take on that first employee that are sort of thinking, what do I need to know here? So do you want talk through the flexible work request for me?
Yeah, absolutely. So all employees will have the right to make a flexible work request. That flexible work request could cover anything from hours, so the hours they work. They may want to reduce from full-time to part-time hours. They might want to request compressed hours, which is where they may continue effectively working full-time hours. However, they squeeze those into maybe 4 days a week as opposed to over the traditional 5. They may be asking to work from home or to work from other locations. So the right to work flexibly really is that they could ask for pretty much anything. That is a right that has been in place now for a number of years, and employers are fairly familiar with it by and large. Those requests can be turned down, and the legislation sets out 8 reasons for why you might be able to turn that request down. But in addition to making sure it complies with the 8 reasons, employers also need to ensure that their reasons for turning down those requests, if that's what they want to do, don't fall foul of other legislation, other overlapping legislation, key one being discrimination. So the right to flexible working, if the employer receives a request, at the moment only one request can be made in any 12-month rolling period. As I said, that's increasing, so the employee will have the right to make up to 2 requests in any 12-month rolling period. The employer then needs to deal with that request, and at the moment they have 3 months to do that. Going forward, though, from April, they will have only 2 months to deal with the request, and if they fail to do that, then regardless of whether they are right or wrong in either agreeing or disallowing the request, the employer can face fines for failing to deal with the request within that allotted time.
Well, that's great. Thanks for the clarification on that. And I think it's always important to get an update on it as well. So because, as I said, there are changes going on. And the other change that you mentioned that's quite a key one, I think, certainly for some business owners and some employers as well, is around the carers' leave changes, where you mentioned about the 6th of April, employees will have a statutory right to weeks unpaid leave to provide or arrange care for a dependent with a long-term care need. I think that's certainly important, especially as we've got an older generation as well and people living longer, etc. But when it comes to that sort of process, should employees actually have to prove to their employer that they actually are in that situation, that they are a carer? How does that sort of work?
It will certainly apply to those who maybe have elderly relatives that they might want to care for. It will also apply to those who care for younger people as well. So it really will have quite an impact for employers potentially. The right will be what's known as a day one right. So that means that if an employee starts working on, say, the 1st of March, well, that very same day they can put in an application for up to 1 week's unpaid leave. And it is important to stress that it is unpaid. If the individual or if an employee wants to apply for leave, they have to give written notice of their request to take it. And there are certain circumstances when the employer can turn down that request, although in reality, the most they can do is postpone the request. And that's only if they can demonstrate that taking the leave at the point it's asked for will disrupt the operation of the business. If an employer does want to turn down the request for leave, then they must give notice of the postponement at least a day before the leave was due to begin, together with an explanation for why they deem that taking the leave would have disrupted the business. So it's going to take some thought for sure.
And am I right in thinking this is on top of holiday requests that employees can put in? So if an employee's got, say, I don't know, say 25 days annual leave, they can also put this additional leave in, but it's unpaid for carers. Is that right?
That's absolutely right. Yes. So they will be able to take that leave in addition to their holiday. The important thing is to note that the employees won't have to take the leave in a whole week. They could take half days or full days. So yes, it'd be interesting to see how it plays out.
Yeah, thanks for clarifying that, because it will be an interesting one, but it's also an important one, especially with people living longer. So be very interesting to see how that pans out. A couple of weeks ago, Jenny, we were at the your business exhibition over at Sywell Aerodrome, and great to see a panel of people, local businesses and business people together, all talking around the report that HR Solutions have published recently. And Greg was on our podcast talking about that a couple of days ago, actually. And obviously, we've got into the subject of AI. Now, AI in the workplace is quite a big topic, I think, isn't it? How do you sort of think it will change the future when it comes to what goes on within the workplace with regards to AI?
Yeah, I think you're right there, Simon. I mean, I was reading the other day, actually, that they've announced that, in fact, this country is now ranked second amongst countries using AI, in actually using AI for both recruitment and HR matters. We come just below India in that, but I found surprising above the USA. So I think it's something that employers will certainly need to understand and get to grips with fairly quickly, given how it is beginning to impact the workplace. AI can be a great tool, and it can really be used in a variety of ways for any employer, through from the recruitment process, and we're certainly seeing that used now, both to analyse job descriptions, picking out skills and qualifications, etc., that individuals put into their application forms, through to also using chatbots to help the potential candidates complete those job applications and answer any questions they may have about the business that they're looking at applying to join. So it's already being used at that point quite a lot. It's already being used as well to screen applicants, and then through to both the time the individual is with the business. So it's being used to help with onboarding. Again, chatbots are often used to answer any questions new recruits may have about the business and the benefits they may be entitled to as an employee. It's also being used a lot with shift scheduling, which we are certainly seeing a few issues with. The other key time that it is being used for is when it comes to ending employment. For example, we've seen it used in a variety of dismissals relating to misconduct, as well as fraudulent behaviour. And there's also been a fairly recent case where it was used, unfortunately, to the employer's detriment in a redundancy scenario. So yes, it's being used a lot. Unfortunately, I don't think that it's being used necessarily with the right level of understanding.
Well, I totally agree with you there because I think with AI, it's all about ideas generation. But when it gets a little bit closer to home, when it comes to things like employees and legal matters, there's a lot of confusing information out on AI, I think. And I don't think you can get the exact results that people expect to get when they put information into AI. So I suppose, it's, well, that's why you are here. That's why you exist, isn't it? To actually advise on the actual legal process rather than maybe what AI returns information when people put it in there around employees and HR and contract matters.
Absolutely. I mean, it has already tripped up the likes of some real household names, such as your Estee Lauder. Amazon have also used it in an HR process to their detriment, and in fact stopped using it in relation to that particular for that particular reason. And we're also aware that a number of unions are certainly gearing themselves up to identify the types of claims employees might be able to bring where AI is used in the workplace. I think the key thing for any employer really to remember is that, one, why are they using it, and what does their AI do? What are they needing it to do? And importantly, is it set up to do that? The second thing they need to do is ensure that they've actually got someone who is overseeing the decisions that are being generated by AI, which sounds daft because you're thinking, well, the whole reason I'm using AI is to avoid having a person that then makes those decisions. But those decisions do need, as I say, some oversight to avoid discrimination, for example, creeping in. And the third thing that employers and businesses really do need to ensure they've got right is that their policies, ensuring that their data protection obligations are being met. So when it comes to their privacy notices, that they properly cover the use of AI in the workplace. So there's quite a few angles that they need to make sure that they've covered.
I'm glad you mentioned about AI policy because I think it's something that's going to creep in as we go forward. Well, it won't creep in; it will become very important in the future because of the clarity that we all need from various situations. And certainly AI at the moment, in my view, it's you can put something in there for ideas, but when it comes to actual pinning down detail on important topics that businesses need to run, then obviously we need to make sure that it's the right information. If not, businesses will find themselves in trouble. So great that we mentioned that because I think it was a real key thing. Was there anything else around AI at all, Jenny?
Yeah, I think that if you're going to use AI in the workplace, then you need to make sure that you've got the policies that you've already got in place are appropriate and don't need revising. And certainly the key policies that we've been helping businesses review and ensure they do align are policies such as your recruitment policies, you bring your own device to work policies, your hybrid and remote working policies, even down to sickness, absence and disciplinary policies. So it really is a case of making sure they're all in place. That's quite apart from potentially having the standalone AI policies in the workplace that really set out what AI is being used for and what those who are using it on behalf of the employers or at the behest of the employers, how that needs using and what they need to be doing with it for sure. And that also aligns itself to ensuring the right training is in place for those that are using it, again, to ensure that there's no inadvertent breaches of anyone's rights really in the use of the AI.
No, brilliant. Great to cover that. Jenny, the big challenge for a lot of employers at the moment is we've had the pandemic, people have been remote working and obviously working from home. let's talk a little bit about getting people back into the workplace from an employer point of view, because some businesses are saying that they want their team back together, but the employees are a little bit reluctant to come back, versus those that are actually saying, well, hey, hold on, it's more economical, it's more productivity gets done because of being able to work from home and less travel. So I thought it'd be really good to sort of touch on that area as well. What's your thoughts around where things are at, given the current world we live in?
Again, it's really interesting, Simon, because we, like so much in life, it seems so cyclical. I think the remote working, the hybrid working is likewise cyclical. I think you're quite right. Many businesses which hadn't necessarily previously embraced the idea of remote working, home working, until the pandemic, then when they started embracing it because they had to, realized actually productivity was up and it was great. However, I think that, again, reports are demonstrating that productivity is reducing as far as home working and remote working is concerned. The other issue that businesses are grappling with is the mental health amongst their employees and how they're managing that. So it is really interesting to see it going full circle. In terms of how businesses are dealing with the return to the workplace, again, that really varies. Some businesses, for example, didn't change their terms and conditions of employment. So the individual's place of work has always been, as far as the contract is concerned, it's always been at the business's premises or not at home. Some companies moved fairly quickly and they changed terms and conditions so that actually the workplace is at home. Others sort of did a bit of meeting in the middle and just implemented policies which provided that whilst it suited businesses, home working was allowed, but that they would be able to ask employees to come back to the office at times that they needed them to come back. So there's a real mishmash there of how different businesses have operated. And the answer to your question really is going to be dependent on which of those categories do the employers fall into. Those employers who have changed terms and conditions as far as workplace location is concerned are going to have a far harder job, I would suggest, or a far longer process to follow in getting people back to the office. And there's going to be a number of hoops they're going to need to jump through in order to demonstrate that this is a change to terms that they are able to push through. Those who have maybe operated a policy or have had it fairly loosely arranged that individuals can work from home as and when needs be, whether that's at the needs of the employer or the needs of the employee, they're going to have a far easier job. But I think in any instance, pulling back to one of the matters we were talking about a little bit earlier, the right to request to remain at work will of course be, to request to work from home will of course be another example of flexible working. So will need to be dealt with in accordance with the legislation.
So if businesses are in a situation where they've got some challenges with that, with employees, not wanting to return to the workplace when the business is sort of saying, I want you back in the workplace, that's where you guys can step in and help advise on?
Absolutely, because although, yes, there are challenges, there are certainly that there are ways and means in which businesses can get their employees back into the workplace. And there was a fairly recent case on that, in fact, whereby there was a lady who was working from home as a result of the pandemic, and she was asked to come back into the workplace. Her contract allowed her to work 40% of her time in the office and the rest of the time remotely if she so chose. So she said, well, actually, my productivity is great. I'm really building amazing relationships with all I'm working with, both colleagues and clients alike. And I want to work 100% from home. And the business said, well, no, I'm really sorry, but that's not something that we can entertain. We can allow a form of hybrid working, so there's some office working and some home working, but she was adamant that she was going to work 100% from the office from home, on the basis that there was no good reason to prevent her from doing that. That has recently gone to the Employment Tribunal. It's important to note that it is an Employment Tribunal decision, which means it's not binding on other courts as it stands. But in that instance, the tribunal were fairly sympathetic to the employer and said, well, no, you've gone through a consideration process, you've considered her request, but you've come up with some really cogent explanations as to why that doesn't work. And in this instance, we agree, 100% home working is not something that we will agree to. And so the employer was quite right in turning down that request. So it's certainly something that can be dealt with, just needs handling very carefully.
Jennie, it's been brilliant to talk to you. Thanks ever so much for joining us, and of course keep up the good work of what you guys do as well within Wilson Browne Solicitors. And thanks for joining us today.
No, thank you, Simon. I really appreciate the invite to join you this afternoon. Thank you.